Good evening, everyone. I am delighted to welcome you all on this class on best practices for drafting international contracts, minimizing legal risks and legal disputes. In today's globalized business landscape, international contracts are the foundation of cross border trade and collaboration. However, navigating the complexities of these agreements can be a daunting task. That is why we are gathered here to explore the best strategies and practices for crafting international contracts that not only protect your interests but also minimize legal risks and disputes. To this end, we have the honor of hosting Ms. Lipi Garg, a contract drafting expert with professional experience in contract drafting, review, and management. Ms. Garg is a contract compliance manager with my legal partners and a contract specialist. An alumnus of Vivekananda Institute of Professional Studies, Ms. Garg has dealt with contract drafting for many prestigious organizations. And I'm sure her experience would be valuable to us tonight. It's a pleasure to have you here with us, ma'am, and I look forward to an interesting and enlightening session. Thank you.
Thank you, Kashish. Can you confirm if I'm audible?
Yes, ma'am, you're audible.
Great. Thank you, Kashish, for having me. So my name is Lipi, as she told, and I have been dealing with contracts, specifically commercial contracts, for the last 3 years. So I dealt with contracts initially in during my internships, and then I realized that I should be doing this professionally, and this is what I am really interested in. So, without wasting any time, I'll share my screen and we can start. Can you confirm if my screen is visible, Kashish?
Yes, ma'am, it's visible. It's visible.
All right, thank you. All right. So, I will be starting with how do you start drafting contracts? Like, what all should be the steps of drafting a contract? Then we will see like things to be considered when drafting or dealing with any international agreements. So there are a lot of things that differ when we draft international agreements, right? So I will be touching on only those points that are different when we deal with international agreements. We'll then talk about creating a checklist of all the clauses to be mentioned. Then an outline. It is somewhat different from what a checklist is. I will explain you how to go about it and how you can actually present this in front of your client. We'll then discuss two MS Word hacks that I personally love and use in my contracts every day. And then we'll see the Q&A session. We'll have the Q&A session. Uh, so, right. So the first thing is, how do you start drafting, right? So this is a very basic uh, like template sort of a thing that I always start with in my Word. So initially is the heading of the agreement, which is always in bold and it is underlined, and a very appropriate heading like a non-disclosure agreement or an employment contract or a sale purchase agreement or a supply agreement or anything of that sort. So very clear heading. Then we start with the execution date, and then we say we introduce the parties wherein we are entering the details of party A and then the party details of party B. We then come to recitals. So recitals are basically an introduction about the transaction of the contract, like what exactly is happening, a very short summary in, let's say, 4 to 5 sentences or something. So we say that, the role of party A is so and so, the role of party A B is so and like justifying their role, we then come to the conclusion that in this particular contract we will be talking about that, for example, A is employing B, right? Or A is providing all the services to B. So hence this contract, right? So in the recitals it is a very short summary of how things are going to be, right, in the contract. So if you want to understand any contract, recitals is the place where you first read up and then go forward, right? uh, then comes the definitions part. Now you might not find definitions in all the contracts, because if the other party or the clients, or let's say both the parties, um, suggest on or decide on having let's say a two pager contract or a two or a three pager contract, then definitions might eat up a lot of your space, and parties do not want that, right? So a lot of times people ignore this, but of course it is always a better decision. If you are drafting a comprehensive contract, you should have definitions there, right? So let's say you have taken up any freelancing work, I would always suggest to have definitions in your contract without fail. So definitions is basically you. Uh, so I'll give you a tip here, that people try to write definitions at the beginning of the contract, right? Like when they start drafting, first of all, they'll write the heading, then execution date, then details of the parties, then recitals, and then they straight away come to the definitions. That is not how things work, right? You might end up including a lot of terms in your later part of the contract and not define them, right? So definitions are always drafted at the end. However, the sequence will remain the same as you can see on the screen, right? But the definitions should always be drafted at the end. You can always use a highlighter or a marker or anything, and you can underline all the required terms that are to be defined, right? And then you can maybe tell the scope of that particular word with respect to the contract at hand. We then come to the operative clauses. Now, operative clauses are those that change with every contract, right? So, for example, let's say if you come across a service agreement, then a scope of work, the payment clause, both of these clauses are operative provisions. They will change with every contract, like every transaction. If you sign a service agreement with me, you might end up putting different payment terms, different maybe mode of delivery of the contracts, or anything, and the scope of work may also be deferred, right? If you sign the agreement with some other service provider. So operative clauses are those that change with every contract, right? So now we come to the boilerplate clauses. Boilerplate clauses are like template clauses. They are very important because they are required to be there in every contract. But you can pick up the boilerplate clauses. You can use same boilerplate clauses across all your service agreements, right? Maybe just by changing one or two terms according to the needs of the clients or the transaction at hand. But otherwise, generally boilerplates remain same across same type of agreements, right? So I am not saying that you don't have to look at boilerplate clauses, or you have to copy paste boilerplate clauses here and there, but you can you have to pay a lot of attention to operative clauses, because they will definitely change with every type of agreement, or any agreement with different parties, right? But boilerplate clauses may or may not change. um, then we come to the annexures. So annexures are attached at the end of the contract when all of these things are written, right? So this is a general layout of how any agreement will work. You have to basically go like this only, right? Cool. So we now come to the important considerations for international contracts. This is basically our focus for this particular session: international contracts. So let's say you are having let's say you are having a contract within India, like it's a national contract. Both the parties are from India, one from Delhi, one from Mumbai. Now, in this case, the governing law will always be the Indian law, right? There is no conflict or dispute regarding the governing law. एक पार्टी ऐसा नहीं बोलेगी कि सिंगापुर के लॉज लगा देते हैं और दूसरी पार्टी बोलेगी नहीं नहीं यूएस के लॉज लगा देते हैं या कैलिफोर्निया के लॉज लगा देते हैं, न्यूयॉर्क के लॉज लगा देते हैं. दिस इज नॉट हाउ एनी इंडियन पार्टी वुड से. So governing law is not a dispute when we draft any national contract, right? But when it comes to cross border disputes, international contracts, then governing law comes into picture. Let's say one party is from England, the other party is from India. Now the party in England might say that let's apply the laws of English, let's apply English laws. And the Indian party might say no, let's apply Indian laws, right? Now whose laws will be applicable is a point of dispute that comes when we deal with international contracts. Now, how do we solve this? So, one thing that is there is party autonomy. How party autonomy works is जो Indian party है and the English party, both of them will come on to a decision that let's keep English laws as the governing law and they put it in the contract. This is called party autonomy. There is a mutual consent between both the parties, and based on that mutual consent, they decide on a governing law and put it in the contract. Now, that will be binding on both the parties. One option is this. Here, no dispute will arise in this case. But let's say if the parties are not able to agree on a specific governing law, then what happens? So, in that case, we always try to apply the principles of, let's say, private international law, or we, let's say, apply the principles of party autonomy. Like mostly party autonomy is applied. People, both the parties come to a mutual consent and they decide on a particular law and then they apply it. If they're not able to apply it in those cases, in those particular cases, what happens is that they try to have a governing law which is not common to both of them. मतलब इंग्लिश और इंडियन दोनों लॉज नहीं लगाएंगे, वो सिंगापुर के लॉज लगा लेंगे, राइट? एंड देन they arrive at a decision that ठीक है सिंगापुर के लॉज लगा लेंगे, and because then both of them will not have any advantage over the other. मतलब इंग्लिश वाले के पास भी कोई एडवांटेज नहीं होगा, and then the Indian party will also not have any advantage. Both of them will land up in a foreign jurisdiction, like foreign governing law, and that will decide how their contract will work. So this is about the governing law situation. Now, how jurisdiction works, मतलब this governing law is sorted in that case. Either it works through party autonomy, or they choose a altogether different governing law which is not common to both of them, right? We now come to the jurisdiction part of things. So honestly, I never suggest my clients to have jurisdiction. I always go for arbitration instead. But अगर for example jurisdiction फिर भी लिखना है, तो jurisdiction का question is solved through, I will tell you how, either through party autonomy, the same case, or we have three types of jurisdiction in international contracts. One is the exclusive jurisdiction. So exclusive jurisdiction will tell you that the provisions of this contract or this contract will only have the jurisdiction of the laws of California, right? This is called exclusive jurisdiction, that the contract itself is saying that only one particular place will have an exclusive jurisdiction. The other part is non-exclusive jurisdiction. Now, non-exclusive jurisdiction will tell you that they will list 5 different jurisdictions and say that Singapore, California, India, England, all of these places can have the jurisdiction, right? So they will tell you that it is not exclusive, not limited to only one place, but let's say they have listed down 4 or 5 places, that any of these places can have the jurisdiction, right? And then there is asymmetric jurisdiction, which tells you that which exclusively tells you that Saudi Arabia will not have jurisdiction, right? Let's say there are 100 countries from which you have to choose the jurisdiction. You exclusively say that out of these 100 countries, 99 can will have the jurisdiction for this contract. Only Saudi Arabia out of this, or let's say India out of this, will not have jurisdiction. This is asymmetric jurisdiction. So jurisdiction problems are generally solved like this or through party autonomies. Now, otherwise, you can always have an arbitration clause, and the things will be sorted through arbitration. And of course, as I mentioned in governing law also, if nothing is written, let's say the jurisdiction clause is missing in the contract by any chance, then the rules of private international law will apply. So private international law ke rules say, there are 4 theories in private international law that deals with jurisdiction part of things. So I will be telling you one theory, or maybe let's say I will tell you 2 theories that are the most important and relevant for this particular session. One is the lex fori. Let's say the contract does not mention exclusively about the jurisdiction, then private, and there is a dispute that arises between the Indian party and the English party, right? So the matter goes to the Indian party, files the case in India. Now, lex fori will happen. Lex fori is basically law of the forum. जहाँ पे केस पेंडिंग है, if the case goes to Indian court, then lex forum will apply, lex fori will apply, and Indian courts will have the jurisdiction to hear that case, right? Another is lex causae, which is the cause of action. Let's say the dispute arose in the cause of action arose in England, then the parties will have to go to English courts, because lex causae is there. So these are the 2 theories that you can read up on private international law. If your contract does not specify anything about jurisdiction, then private international law rules are applied. Um, so, yes. And one more thing that I want to cover in jurisdiction is that so there are countries that have different legal systems, or work on federal um, system, right? Let's say US. Now, if your contract is saying that the jurisdiction of this particular contract uh, is USA, now this is wrong, because USA has 50 states. All of them have different laws, different legal systems. Now, which states ke law will apply or will have jurisdiction in your contract will differ. So instead of saying that the jurisdiction of this particular contract is USA, you will have to write California ke laws lagenge, the jurisdiction is California, the jurisdiction is New York, or the jurisdiction is Delaware. So you need to be very specific when dealing with countries having different legal systems or having a federal structure, right? So this, then the delivery terms. Now let's talk about a situation wherein you are an Indian trader and you go to China to import stuff. Now, in this particular case, this is a sale purchase agreement that will happen between both the parties. Now, delivery terms might differ when you are dealing with international things, because you will deal with a lot of things like um, bill of ladings, Incoterms. All of these are shipping terms. Incoterms. Incoterms are basically international commercial terms. They are only dealt with when you are shipping goods from one country to another. So it will definitely happen when you are importing goods from China, because most of the goods are come through ship via ports. So a lot of delivery terms are there, like, who will, when will the ownership or the title of the goods will transfer from one party to the other, and when will the risk associated with the goods shift from one party to the other. So all of these things are determined in the delivery terms. So these are very essential components when you are dealing with a sale purchase, international sale purchase scenario. So this is a very important clause that you should be paying attention to. Then we come to the payment terms. Now payment terms will have, let's say, uh, in which currency are you guys going to do the transactions, which payment method will you be choosing. And let's say you are choosing PayPal, for example. Now PayPal charges you a lot. Who will be bearing that commission, right? So all of these specific terms. Now it might not matter when you are a small business owner, but it may matter because the amount becomes so huge when um, the parties are transacting again and again, and the commission that you are paying to these channels is so much that it becomes a point of concern. So what will be that then? Who will be bearing all the taxes? Then the current currency rate, like what will be the currency rate to which you guys are agreeing, right? So payment terms is that. And like which currency rate are you considering in your contract? Let's say US dollar का price आज 80 rupees है when you are, signing the contract. But when you deliver the goods उस time 90 rupees हो गया. तो कौन सा माना जाएगा दोनों में से? So you have to specifically mention, of course, the standard practice is that the currency rate on the date of signing the contract is considered. But a lot of times parties argue that the difference is a lot, and they will not be able to um, complete the contract just because of this, right? Then we come to the mode of communication. Which mode of communication will you be using? Will you be using emails? You will be using WhatsApp? Because these become a point of concern when you are dealing with Chinese suppliers, because they don't use a lot of these they don't use Gmails, they don't use WhatsApp, all of these, right? So how will you be communicating? And yeah, so mode of communication is a very important concern. And which are the official modes of communication, right? So you will have to list down those things as well. And then of course, if you have a calling number, then what is your calling number and what time can I call you? All of these things are also included in the mode of communication thing. Then is the time difference. Now, this becomes a point of concern. Let's say you are a service provider who drafts contracts. Now, you work for a US firm, they get contracts outsourced. Now, let's say they told you that सुबह 11 बजे तक you have to do this. Now, किसके 11 बजे? Your 11 a.m. or their 11 a.m. So time difference will matter. So you have to also write in your contract that which time, uh, like which country's time are you going to follow throughout the course of engagement, right? So time difference is a concern because a lot of times the service provider will say that मुझे तो लगा 11 बजे इंडिया का, so I have not prepared it, and then they breach the deadline, right? So just to avoid ambiguous situations, you have to mention all of these things while you are contracting with international parties, right? Hmm. Next is a checklist of clauses. Now, so how do you move when, let's say, you get a query from, I'll say, LinkedIn, right? So you get a query from LinkedIn that they want a service agreement to be drafted. Now, service agreement is not a very complicated agreement. That's the reason I have taken service agreement as an example for this particular session. So let's say a client comes to you that I want a service agreement. So what will you say? So you will be telling them that, hey, okay, You will be asking one or two questions that, what type of services do you provide and all of those things, right? You will be asking those questions. Then they will ask you that how much do you charge for a service agreement. Let's say you tell them that I charge $100, right? Now this is an international thing, right? So you say, they will agree to it that this works. Now you will say, let's get on a call to discuss this further, right? So what will you do? um you will get on a call, you will schedule a call with them. You will obviously research on how service agreements work and everything before getting on a call with them, because you might not want to land up in a uh, embarrassing situation wherein they ask you questions and you do not know answers for them, and they might not even get onboarded for that particular service of yours. So, and you always have to give something extra to them, that how many clients have you dealt with in the past, what type of experiences have you had with them, whether you have drafted any service agreement previously, and how did you help them, and all of those things, right? So what I do is, I whenever I enter into a situation with a client, I will be dealing with outlining first. So I usually take a document with me printed out always. So I'm an old school person. So I take a document printed and I take it in the meeting. Now, how does that document look like? Let me show you. Hmm. So the document looks something like this. I will write the details of the parties, whatever they tell me. And give me a minute. Yeah. So I will write all the recitals that I think, and then I will take this outline with me in the session and I will start writing everything. I will ask questions. So I will first wait for the client to tell me that what exactly are they looking for in the contract. Once that is done, they are done with everything. You can write this on the back side of the paper, whatever they tell you. Now you will start asking questions based on the outline that you prepared. You will ask them that, hey, आपको क्या चाहिए exactly, what is the scope of services that you want from the other person? If you want a contract from them, how much time do you want to give them, and how many revisions do you want? Like, let's say they give you the document, and then let's say you did not understand, so do you want a review meeting, clause by clause explaining you? Then, so you write all of these things here. Then, you will ask them that how exactly do you want to get, you want to pay the other person, and how much will do you pay to them, what is the taxation system that you're going to follow, payment method, of course, and in how many days will you be paying? Let's say 50% will you be paying in advance, or 100% payment will be paid in advance. How will that work, right? So I carry such a checklist, like such an outline with me in the session, in the first meeting, and then I write all of these questions. What this allows me uh, is first impression making. The other person will feel that this person knows what he's speaking, and I will always have an upper hand, because when you do not have things written, you forget, you tend to forget a lot of things, right? You might forget a lot of clauses, and then you will later ask the client that, hey, what is the answer to this question, how will you be dealing with this situation, and all of those things. Clients do not appreciate that. They are getting the work outsourced because they do not have time for all of these things. So if you are eating their half an hour or 1 hour in a meeting, then make sure that it is productive and you have everything written, so that you also have a proof that I took these notes while in our first meeting. And you cannot, like, the client cannot tell you that Why did you write it on your own? Right? You are asking all the questions and forcing the client to think in that particular direction. So it is a twofold thing. So try to make a habit whenever you get a client, try to make an outline. Now, what my so sorry. Yes. So what my previous slides were telling was a checklist of clauses. So I wanted to show you the outline first so that you understand the reason behind this checklist. So I prepare a checklist. I do a thorough research of, let's say, 1 to 2 hours, based on the information, first hand information I received from the client during the query, that I want a service agreement and I want someone to draft contracts for me. And so based on that, make a checklist of clauses, all the possible clauses that can come to my mind, and then I put it in my outlining document. Where is the outline document? Yes, I put it in my outline document and then present it before the client. Right? You do not have to present your screen, of course. Just take a hard copy of this when you're in the meeting and take notes. The client will always appreciate that. Now, a lot of people ask me that how do you research? Like, how do you keep upskilling yourself and how do you know a lot about so many contracts? So, to deal with such situations, I have a sheet. Let me just a second. Hmm. I have a sheet. I call it my research sheet. This is a sample one. Just wait a moment. Hmm. Cool. What I do in my research sheet is, let's say I receive a query for service agreement. And not only when you receive a query, you can do this exercise when you're free or starting out your freelancing services. Um, you rename the sheet here, then you come to clause, and then let's say you write here scope of services. You write what is the meaning if you want to write, but it is not required in this. Let's say it is a non-solicitation thing. Then you can write that what non-solicitation agreement means. People who are drafting contracts for the first time, they might not know the meaning also. So this comes handy. Then components. So let's say in the scope of services, you write revisions, exact services that you want the other person to maybe draft. And then let's say you also want a meeting with them after the delivery of the contract. Then let's say you also want editable Word document of the contract, and you also want a PDF version. Both you want, right? So these things will come. Now let's say you have a payment terms ka clause. You will write payment method of payment, late payment कैसे deal करोगे, then taxes, then mode of payment. Let's say these things only, right? Now how will you research on these things is that you start reading up on a couple of, you take, let's say, 5 service agreements from the internet, and you read their payment terms, you read the scope of services, and then you realize that these are the possible things which can be added. These can be made more comprehensive. The more drafts you read, the more comprehensive you can make these clauses for yourself. And you don't have to use all of these components in every contract. You can just see which all will apply to your situation at hand, and then you can apply accordingly, right? Then is a sample language. So sample language is for beginners who do not have a lot of experience with drafting contracts. What they can do is simply is they can copy some templates, like the sample language from some templates, just to practice of how language works in a contract, right? And then you put resource links. So maybe you can create a repository for yourself for all the resource links, put here, and you're good to go in that case, right? So whenever you want to go back to the agreement again to see if any other clause will be might be helpful for you, so you can write all these, like mention all the links of those particular resources. So this is a research sheet. This is the first step. If you are a beginner, you do not know how to draft contracts, this is your first step to learn drafting, because you do not require anyone's assistance in this research sheet. And I have at least done this for more than 50 types of agreements. I have my repository. Whenever any client comes to me, I can draft their contract within 2 days, just because I have all my research ready. And I keep updating these with time. So whenever I come across any other new sample, or I come across any new term, I come across any judgment that how judges dealt with any particular thing, I just make a note of here, of that here in my sheet, and it is a very solid compilation of all the research and resources that you have, and it is going to pay you a lot. Trust me on this, right? So this is a research sheet, this I've shown you. And cool, now we come to the MS Word hacks. Now MS Word is something, whether you are a first year student, you are a fifth year student, or you are a lawyer, you will need MS Word right from the beginning of your law journey. MS Word. So I personally, I did not know how to use MS Word because my school did not teach me. So during COVID, I took a course on MS Word. It was a very, uh, you know, very affordable course. I took it from Udemy. I'm not promoting any course, just saying that you need such courses. It was for I think 399 or 499 if I'm not wrong, and it was a very lengthy course. And I was very free during my COVID, like during the initial COVID wave in 2020. So it took me 7 days to complete that course, but I thank doing that course in those times, because today we do not get time with, let's say, managing college, managing assignments, managing work. We do not have time to learn a thing like MS Word. So of course I did not I did not learn these features when during that course, but eventually when you know the basics and some advanced things in MS Word, then it becomes very easy for you to apply advanced things or tricks that you come across every day. So I usually post about MS Word hacks that I come across um, every now and then on my LinkedIn profile. But I would want to show you two MS Word hacks that can be useful for you every day. Right. So let me tell you about quick parts first. Let me give you some background for quick parts first. So let's say you we talked about boilerplate clauses. Do you remember that the the matter ultimately will remain same, but some things might change in a few contracts, right? So for a boilerplate clause, what you can do is, this is like saving it in a gallery. You select a text and then you save it to MS Word, and it will be saved as a quick part. It will be saved as a part in MS Word. And when you open a new document, suppose you want that particular clause here, you can just click on quick paths and then you can add that particular thing here. So it works like magic. You do not have to remember that I drafted a very nice boilerplate clause in that agreement. Let's find that document first, then let's copy paste here. So you don't have to juggle between multiple documents. You can just open one document, and whatever you draft, let's say you have a very nice table for maintaining list of dates and events, very nice table, very good formatting, very good content and everything, very comprehensive, right? So you just select the table and then you save it to quick paths. Whenever you open any new document, you just say go to quick paths and then select on that table. That table will come automatically to your new um, contract, the new document, right? So let me show you how quick paths work. So I will show you a tutorial that I posted on my LinkedIn. Cool. So here it is. Great. So, did you see how I used one particular document and I selected a particular part and then I saved it to my quick parts gallery, and then I open a new document and just insert from the saved template and it appears to me, right? So you can I will be sharing this document with LawSikho. You can contact them if you need the link to this post, and you can see how this will work, right? So I have mentioned all the steps also, and of course you can see this in your um, laptops. Yeah, so you can see this on your own as well. Great. So the second feature is compare documents. So how compare documents work is that let's say um, you sent a draft to the client. After drafting the first part of it, you share the first draft with them, and they send you a revised version with their comments on it, but they forgot to turn on the track mode, and they made the changes there only. Now it becomes very difficult for you to track that what all changes did they make to your document. So compare documents in that particular scenario comes very handy. um, it lets you upload two documents at one point, and then it will tell you that where all it will differ. Of course, compare documents is available on internet, like different tools are available, but what better if Microsoft Word itself is giving you that feature. So you upload the document one here, and then you also enter the revised copy here. So in the revised document, you want the changes to be marked. See, you will see everything, that what all was changed in the two documents. Right, so this becomes essentially helpful when clients forget to, or any of your so anyone forgets to switch on MS Word ka track mode or Google Doc ka editing mode, sorry, review mode. So in these cases, this is also a video that I uploaded 1 year back on LinkedIn. Very simple steps, it very simple. Just go here and upload both the documents, and you are ready to compare them, right? Cool. So I am done with my presentation. Let me stop sharing and see if we have any questions. Cool. Hi, Kashish.
Thank you so much, ma'am. That was a very interesting session. Uh, so, if you don't mind, we can wait a minute or two for the questions.
Definitely. Um, so do you want me to share these links anywhere in the chat or something?
Ma'am, maybe you can post them in the comments. That way, they will like be in the
Okay.
comments of this session. This will go up on YouTube after this. So.
Okay. I'm sending you on your private chat because I'm not able to send it there. I've sent you both
Okay.
the links.
Put them up. Uh, so, so, ma'am, I don't think there are any questions for now. So, if it's okay with you, we can. I think you're on mute.
Yes. Can you hear me now?
Yes, ma'am.
Yeah.
So,
All right. No worries.
so
I
we can
think we
end
can
it.
end the session in that case.
Thank you so much, ma'am. Thank you so
All
much for
right.
taking your
Thank
time
you.
out for
Thank you,
this.
everyone.
Thank you, ma'am.